I mean, you do want to get an idea of each party's view of their case, but that can be gleaned from the mediation brief, like I said. But the session would highlight the key points, so you can sort of gain an understanding of, what are really the key issues that they're going after for the mediation. And there's also things that a mediator can do to make the session effective. And I know that different mediators will do it differently. If you have worked with that mediator before, you might have an idea of, how they like to do things. If you haven't, then it's still a good opportunity, because you can go in with an open mind and sort of, answer questions as they're asked, and engage in the fact-finding process if there is one. So for example, some mediators, what they will do is they will make the opening session more of a fact-finding process, where they will say, here's my understanding of the facts, and we'll get the parties to agree on some points by focusing less on the differences. And the parties should be prepared to explain the situation and facts as needed. So instead of it being, a formal session where you're sort of having to debate the merits of the case, more likely than not, it's going to be a situation where the parties sort of gaining a deeper understanding of where the key issues lie.
Yeah, great. Thanks, Nadia. And I think that's really helpful, just in sort of helping people understand what they can expect, just because that way, if you finish the opening plenary and the client says, but the other side didn't make an offer, you can sort of try and manage their expectations appropriately. So that was really helpful. Thank you. So just, then going beyond that opening plenary and thinking about the mediation day more broadly, what else can be a good use of time apart from that opening plenary and in the usual caucus meetings? So for example, what about meetings of expert witnesses during that mediation day? What are the promises and pitfalls of having experts engage in the mediation process?
Yeah, so that's a great question. And this is largely going to depend on the nature of the case. But for example, let's say there's a real issue relating to medical evidence, and it would help the parties to assess their risks of the matter proceeding to litigation. It might be helpful to hear from an expert, and the mediator can then also assess, what the risk analysis would be of the parties proceeding to litigation, and sort of reiterate that during the individual sessions to each party to get them closer to a settlement. And I can tell you that in employment law, this doesn't come up as much, but I can imagine it coming up more in other types of cases. And generally speaking, when it comes to employment law matters, for the purpose of the mediation, I mean, obviously you'll want to have, if there's a medical documentation or report at play that's relevant, you will want to have that there, and you can mention that to the mediator if that's going to be helpful for your case. But generally, you wouldn't really see expert witnesses in most of these types of mediations, but in others, it might be very helpful if there's a key issue that needs to sort of be sorted out, and you want to assess what the risk is. And I think you had another question tied up with that, but if you could repeat that, that would be helpful. Oh, you're on mute.
Sorry, it was just thinking about sort of structuring the day in,
right,
in more general terms. So for example, is it ever useful to have a mini caucus, so a mini plenary later in the day, or are there other ways of structuring the day that are a good use of time apart from the usual shuttle diplomacy?
Yeah, that's a great question as well. So yes, I would say that there are circumstances where a further session can be effective in helping progress the mediation. So for example, sometimes there will be a holdup on the defendant's end. So for example, it could be a situation where counsel does not have instructions to go beyond a certain amount of money, and they're having trouble getting a hold of the key decision maker who they're trying to connect with over the phone. or let's say the defendant is not doing well financially, and they have strict instructions from before to not go beyond a certain amount. So maybe that's where the holdup is. And even though they would like to take it back, it's just a situation where they can't confirm right at that moment. So at that point, it's a situation where the matter has almost settled, and you might have a notional settlement, but you might either later on the same day, or after the mediation day even, be working on the mediation process. And it could be continuation of the mediation process as well, where you're sort of trying to finalize the terms of the potential settlement. So it doesn't necessarily have to be on the mediation day. It can also be afterwards as well, and it can actually be helpful where the parties are, very close, but need to sort out some of the details still.
Yeah, that makes sense. Super. Thanks so much for that, Nadia. That's really helpful. And I should have said at the outset, actually, we've got some time at the end of the session for Q&A. But if anybody would like to put any questions in the chat, then we can pick them up towards the end. Or alternatively, when we get to the Q&A at the end, then obviously feel free to unmute yourself, and we can have a discussion at that point. But with that, again, thanks so much, Nadia, and we'll pass it back to Afsana.
Thanks, Donny. So the next panel is Gary will be helping us out here, and I've got a few questions for you, Gary. And the first one being that what some of the issues or circumstances which a mediation can lead to an impasse. So what are some of the situations that can occur that really hampers our chances of succeeding to a final result?
Yeah, thanks. So impasse in 15 minutes, no problem. Here's the main ones. I break it down by three. The biggest, and not necessarily the biggest, but the first one is impasse around process. So when any party sees the process as either biased or unclear or unsafe to share information in, they'll withhold that. And by withholding that, parties don't have good information, it will quickly lead to an impasse. One of the manifestations of that is what I call negative reciprocity. And so if a party starts the mediation with an utterly unreasonably high or low first offer, the other party feels compelled to reciprocate in the same ballpark, although in the other direction. And we end up with really a spiral of negative reciprocity. You sort of get, oh yeah, well, if they think that, they're offering that, then we're going to offer this. And it becomes a way to trade insults in the process instead of genuinely trying to find common ground. So if the process is not run well, it can lead very quickly to what I put in the category of impasse around bad process. Probably the biggest one are I loosely call emotional psychological impasses. And that's where you get a party that becomes motivated by winning, by making sure the other party doesn't get something, I put this in the category basically of parties start coming at it from a real red brain perspective. It's I'm going to teach the other party a lesson. Sometimes it's just born out of what is called loss aversion. Human beings hate losing. So if they come in anchored around the minimum I'm going to accept is $100,000, whether it's realistic or reasonable or not, anything less than that is seen like I'm losing money or losing something. And anytime a party perceives a loss, they will dig their heels in and just simply say no. Even if there is a potential greater loss in the future if you litigate. Today, they have a hard time getting past this bias we all have that is typically called loss aversion. Substantive impasses, interestingly, in my experience, are the least common, meaning where we genuinely can't find a number that would work for both of us. If the only thing we were focused on was the monetary side, we can resolve those almost every single time. There are a few where the numbers are just so far out of whack. But generally speaking, money is representative of things like who wins the case, who's getting more than the other party. It's very common when I have multiple defendants for a defendant to say, look, I could put 100 grand in today, but I'm not going to put $1 more than that other party is going to put in, and they're only putting 5,000 in, so all I'm going to put is 5,000 in. And that's not a substantive problem. That's a problem back to either process or the emotional psychological impasse of I'm not going to be stupider than that party by putting more money in. So we have to assess. I'm very cautious about assessing what kind of impasse are we hitting, because it will greatly determine then what we do about it.
So that leads me on to my next question, Gary. What do we do about it? What are some of the methods we can use to overcome impasse?
So one of the things I do, and I'll start again in the same sequence, if the issue is around process, the first thing I do is sometimes just meet with counsel and say, how do you want to proceed? Like, what would actually work for you in terms of this being a process where we can get to the heart of whether we can settle or not? And sometimes it's, well, they haven't shared this piece of information with us, or and we negotiate the process. The other thing I counsel parties to do, and usually I'll get at least one, if not more, parties that are really there to try and take a good run at settling. I then say, I sometimes call them confidence building measures. I say, make an offer that demonstrates you're serious about resolving it. Because if you make an offer the other party sees as in the ballpark, they will positively reciprocate with an offer that they see as in the ballpark. And when each of you see the other is working into the ballpark, it gives us momentum toward actually resolving it. And that's what I call positive reciprocity. There's also some process approaches good mediators use. And this one is very near the end of a negotiation, where parties may still be noticeably apart, but not completely at their starting points. And you may run into this. It's called a double blind. And that's where a mediator will make a proposal at near the end, not generally on the basis of what's fair, but on the best number that he or she feels might have a chance of settling. And each party only has to tell you yes or no to it. And if both parties say yes, you have a deal. If both parties say no, neither party learns what the other party said. And so it protects the integrity of it. If I say yes and you say no, then I know that, you've said no. I know I've said yes, but the other party never learns that I was willing to say yes to that number. So it's a safe procedural way of truly testing if we can find a substantive settlement to the problem. If the problem is the emotional psychological interests, that idea of loss aversion, sometimes good mediators will help the party re-anchor or unanchor from what they perceive as a loss. So if they say, if the plaintiff has nothing today, but they want a minimum of 100,000, you've probably had mediators who do a best and worst case analysis for you to say, look, let's assume you win. Let's say you win $100,000. Your costs are going to be 80,000, but don't worry, the other side will pay half of those at least. So that's 40. So you will walk with 60,000 in your pocket. That's a good day for you. Help me understand why you're holding out for 100,000 when if you go forward and win 100, what you actually get is 60. And what I'm doing is shifting the anchor from 100 towards 60, so they then perceive 70,000 as actually a pretty good offer. Whereas at the beginning of the mediation, they saw 170,000 as an insult. And that's by shifting on that loss aversion scale where the anchoring point is. And frankly, sometimes it's just people are mad. People are hurt, they are mad, and it's the mediator's job to listen to them, to acknowledge what they've been through, not to agree with them in any way, but just to say, yeah, it sucks. And if you think you're mad today, if you go forward and you're not only not going to get 100, but you're ordered to pay 30,000 in their costs, how mad are you going to be then? And I'm helping them process some of that so that they can say, okay, what is in my best interest today. Not what I think they're getting away with, but what's in my best interest today. And on that emotional, psychological level, I like to really help them focus. And I use counsel, and good counsel do this as well. They say to their client, we're here for you. We're not here to win today. If we go to court, it'll be to win. But today we're here to get the best outcome for you. And I work with counsel to help their parties see that as well. And obviously it depends on the facts of the case, what the numbers end up at. And if it's really seemingly about the money, I help parties look at other interests that they often forget. So if I'm dealing with small business people, I'll look at a client and I'll say, so how much do you value your time? Like, what's your dollar figure for your hourly rate as a business person? Because you're going to spend hundreds of hours going forward. And how are you factoring that in to the cost? If you just want to talk cost, let's talk cost. How are you factoring that cost in? If you're a business and you have staff, how much of your staff time is going to be taken up by this? What could you be doing with that time in terms of earning other money? And what's your lost opportunity cost by this litigation? What's your reputational cost by this and so what I'm doing is, if it's purely seemingly substantive, I expand their view of other interests so that they can make a decision that meets a very broad sense of interests. One of my favorite ones was I did a construction claim and the two parties just hated each other. And so near the end, I said to the plaintiff, I said, you must really like that other guy. And he goes, what the heck are you talking about? And I said, well, you're signing up to deal with him for the next 3 to 4 years. You're going to be seeing him regularly. And he looked at me kind of blinked, and we were about 40,000 apart. And I came back in and let him talk to his counsel. And he said, I'm accepting their offer. For 40 grand to never see that jerk again, that's a deal. That was alone what settled that one, because they hadn't thought of some of these other interests. So I will work on all 3 different types of impasse a little bit differently.
Well, that's very interesting, Gary. So what happens if you can't come to a settlement? What can mediators do after with the parties?
Yeah. I think this is really important, Afsana. And it depends on, obviously, case by case, but many cases, what we're asking parties to do is actually pretty crazy. Someone who's been in litigation for multiple years, they have only spoken to their counsel and themselves and their family and their friends, and everyone tells them, you were wronged. You're the one who is the injured party here. And then we bring them together for 6 to 8 hours, and they have to completely shift that view and look at the problem differently and reach a resolution that they swore they never would. And we ask them to do that in 1 day. And we're successful 80% of the time, which still shocks me, quite frankly. So what happens at the end of some of these is they just can't get there in a day. We've made good progress in the sense that they've rethought it. They have reprocessed it. They've looked at the problem differently, but they cannot make that decision today. And so if parties get anywhere close, as a mediator, I follow up with counsel within a week, and I say, listen, how can I help you move this forward? Your client was talking about something like this. If I called the other side and explored, not on your behalf, but on my behalf, if they're willing to consider that, would you go to your client and have them consider it? And lots of times they've moved the markers close enough, people go home, they sleep on it, they've had a taste of maybe walking away with a settlement. And if we don't pursue that, we've lost another opportunity. So whenever I get the sense that there's been some movement and parties are considering and processing this, I will absolutely follow up. And I do it on my behalf, meaning I don't want either party to feel like, oh, other party called you and told you to talk to me. They're on the run. They're feeling weak. Good, we'll take advantage of that. So I do it on the mediator's behalf, which frees both parties to continue saying, well, I'm not doing anything necessarily, but both of them actually want to get there. They just don't know how. So I do follow it up. If there's absolutely zero prospect, or there's not enough information, or yet, or one party is just absolutely wants to litigate it, then we all acknowledge that, and we're heading off to the races.
Okay, great. So guys, you'll have an opportunity to send Gary some questions. If you want to put some questions in the Q&A box now, please do so. And Donnie and I will come to those toward the end of the presentation. It's really interesting what you say, because Gary, impasse is one of the hardest things to come by when you can see the parties are so close. So if you guys do have any questions and want some more tips or tricks from Gary, do stick around. But we're going to move on to Donnie now. And you know, in the mediation process, clients will at some point face a decision about whether or not to accept a settlement offer at a compromise level, or to decline the settlement and carry on with litigation, you know, as we just heard from Gary. There are often difficult decisions with significant financial consequences. And Donnie has spent the past few years working on tools and techniques to help clients with the decision-making process. And he is very kindly going to talk us through that now.
Super. Thanks, Afsana. Can I just check whether everyone can see the slides are displaying all right?
Yeah.
Yeah, super. Great. So in our next segment, I thought I'd talk to you about supporting client decision-making during a mediation with the help of some of these slides, and then we can have some Q&A after that. The slides have gone around before, and in the interest of time, I won't go through all of them, but they're there for you to refer to later. So as Afsana said, a large part of my practice over the last few years has been providing a specific service for clients, which we refer to as decision analysis. So what is it? It's essentially a set of tools brought over from my past life as an accountant, which analysts use when helping businesses to analyze risk in other non-disputes contexts. It involves the building of decision trees and the proper financial analysis, as Gary was alluding to earlier, of all the different possible outcomes to ensure that they can be properly compared with each other. And so how is it relevant to mediation? Well, as Afsana said, if a mediation is going well, then at some point during the day, the client will be faced with a difficult decision. Do I accept the offer in front of me, or do I reject it and carry on with the dispute? And that's a decision that they've got to make in the face of legal uncertainty, because they don't know what will happen if they carry on fighting. And what tool does their lawyer usually give them to help them with that legal uncertainty? Well, they usually get a long and dry memo with an ambiguous paragraph at the end that says, you have reasonable prospects of success, or something along those lines. Now, thinking about what impact that has on people, well, social psychology research shows that human beings tend to display judgmental overconfidence in the face of risk. They tend to underprice their downside risk and overemphasize the upside potential. And that extends to professionals as well, and to lawyers. And so we can see this because actually two sets of lawyers can analyze the same case, and because they're living the case from different points of view, not just in their advocacy, but also in their confidential advice, they might take different views of what the case is worth. Now, we've often heard commercial clients say to their lawyers, your intricate legal analysis is all very interesting, but just tell me the answer. What is the percentage chance that I will win? Just give me the number. And lawyers have historically found that to be quite an uncomfortable position. And when they do put a number on it, they're often quite conservative. So they switch from this overconfidence when they're valuing the case from their gut to a degree of conservatism when they've got to put a number on it. And what this analysis can help to do is to bring that overconfidence and that conservatism face to face, play them off each other, and try to find more of a middle ground in the risk assessment. And by doing this properly, we can help clients to quantify, visualize, and ultimately better understand their litigation risk. But critically, it's worth saying that actually by putting a number on it, we're not pretending that we've got a crystal ball or that there is some statistical database of thousands of cases exactly like your case to predict the outcome. The risk assessment, when you put a percentage to it, is still a subjective risk assessment. It's still the lawyer's judgment as to what the merits of the case are, just expressed in a number. And then once you've done that, each client also has a different risk appetite. So it's not saying there's a single correct answer as to what to do. each client can then think about how it feels about that risk. But even though it is subjective, my thesis certainly is that it's a good discipline to put a number on it, because at least it's unambiguous. And the example I like to give here is from the 1960s, when President Kennedy was thinking about ordering the invasion of Cuba. The sort of lore goes that he had asked his intelligence advisors what they thought the prospects of the mission succeeding were. And at the time, the intelligence community actually had a rule against putting numbers on things. And so they came back and they said to him, it has a fair prospect of success, which for the lawyers among us will sound familiar. And of course, we know that he ordered the Bay of Pigs invasion and it failed terribly and led to perhaps one of the biggest crises of his presidency. But what we also know is that they then went back and they did a sort of a post-mortem on the intelligence analysis. And they asked, well, why is it that you said fair prospect? What did you mean? And the team that had done the analysis came back and said, oh, about 20%. And that just shows that context is everything, right? If I tell you to buy a lottery ticket, it's got a 20% chance of succeeding, you'd say that's a fantastically good deal. If I told you to get on this plane because it's only got a 20% chance of crashing, you'd treat that as an intolerably high risk. And so the context really does matter, and it's for the client to decide what that number means to them. But if you give the number, at least you avoid any ambiguity as to what it means. And we can all imagine what President Kennedy might have done if he'd been told this only has a 20% chance of succeeding. And this sort of analysis also has value for corporate governance purposes. I had a client a couple of years ago reject a $120 million offer on the basis of a decision tree model that I had done for them. And that was an incredibly hard decision for them to take. It was a $1.3 billion claim. And so the offer was only about 10% of the face value of the claim, but objectively it was a huge number and it would have made a huge difference to the business. And so the board had been incredibly torn about what to do and really nervous about the repercussions they might face if they reject the offer and lose the case. Using this sort of analysis, we were able to build a consensus amongst the board within about 45 minutes to decline the offer and fight on. And they very quickly got comfortable with that decision because they could say that even if they eventually lost, they could show they had a reasonable basis for taking the decision. And in due course, with the help of a sort of 2-mediator team over the next 13 months, we eventually got them 4 times that amount. And I also use this when acting as a mediator because it helps parties to properly see their alternatives to settlement and to weigh them properly. And so I've tried to illustrate this using a case study. In the interest of time, I won't go through this in detail, but you have the slides. So please do have a look at the details and feel free to get in touch later if you've got questions. But broadly, this is a fictional case where we assume we're acting for the claimant in an arbitration. It bought a food business for $150 million. That turned out to be a big disappointment. And it's seeking $100 million in damages for fraudulent misrepresentation. Or alternatively, if it can't get that, then $75 million for breach of warranty. And it's been told it has a strong case, 70% prospects on misrep and a 60% prospect on warranty. But it also knows that it has to spend money to arbitrate, and that will cause delay. And there is also enforcement risk. And so against all of that, it's now got a 30 million settlement offer on the table. And the difficult decision is, what should it do? It doesn't want to let the sellers off the hook too easily, but it also sees the value of cash in hand today. And so we would represent that decision for the client in the form of a tree model that looks like this. The decision that they've got to take is in the bottom left. Do they arbitrate or do they settle? If they settle, they've got certainty. They know they're getting 30 million. If they arbitrate, there are, broadly speaking, 3 possible outcomes. They could succeed on fraudulent misrep, or they could succeed on warranty, or the claim could fail. And if the claim fails, they know they're losing their own costs, plus they're paying something towards adverse costs. And then you can say, well, if you succeed on fraud, that's not the end of it. You've got to work out what the actual outcome is. So there might be a dispute about quantum of damage. there might be an issue about enforcement in a foreign jurisdiction in this example. And so you can work through the different ways in which the case could play out. And I said earlier in this example, we're assuming that the best case outcome is a $100 million win. What you'll see in the top right of this slide is that actually the best case outcome is shown as just under 78 million. We'll drill down into that in a second. And then the next slide over here shows what happens if the client fails on fraud but succeeds on warranty. Broadly speaking, the quantum figures are somewhat lower. And I mentioned that we would come back to that 100 million best case outcome. Your client may be fixated on the idea that their claim is worth 100 million because that's the headline number. As Gary said, there's an anchoring effect. But what we would typically do in this sort of analysis is work out the actual cash flow value of that outcome in today's money to make it properly comparable with the settlement offer today. And so what this calculation shows is that once you take account of your costs that you've got to expend to fight it, a partial cost recovery, and then the time value of money, it's actually worth materially less than the face value. And so once you've done that for all the different possible outcomes of your case, you can put together for your client a dashboard that looks a little like this. Over on the left-hand side, we've identified all the different possible outcomes of the case, worked out their financial value net of costs in today's money. And because we've attributed probabilities to each issue in the tree as we've gone along, we can work out how probable each of these individual outcomes is. And now, of course, this is not, as we said, statistical certainty. This is an expression of confidence, but it still allows you to get an overview. And then you can generate some benchmarks over on the right-hand side. So you can say, if I fight this, broadly speaking, there are 4 different possible winning outcomes and 3 different possible losing outcomes. I can get a weighted average. So I say, on average, actually, if I fight this, my average outcome is just about 32 million. So that's one benchmark. We're not saying that that is the answer. If you get an offer better than that, you must accept. And if it's worse, you must reject. It's more to give you a sense, a bit of a benchmark of what the litigation looks like. It's also worth looking at what your range of outcomes is from worst to best and ask yourself, am I ready to tolerate that downside risk if it happens? You can also look at the table and you can say, well, what's my overall chance of a losing outcome? Well, all your losing outcomes add up to about a 40% chance altogether on this example. And that can be a useful benchmark or metric for clients to think about. Now, you might also say, well, it's not just losing. What about doing worse than the offer? At the moment, there's a 30 million offer on the table. If I fight this, actually, it's about 50-50, whether I do better than that offer or worse than it. And so that can also help me get a sense for what the case is worth. You can represent that visually in a distribution chart that looks like this. Broadly speaking, the yellow line is the offer. The blue lines are the different possible litigation outcomes where their height represents how likely they are. And you're really asking yourself, am I happy with this offer? Am I ready to buy off the downside risks to the left of that yellow line and ready to give up the upsides to the right? Now, it's also worth sort of noting that you can, once you've built the model, you don't have to accept the inputs that you've put in. You can test them. You can say, well, what happens if I take a particular input and tweak it within a range? How much does the overall valuation move by? And how does that compare with my 30 million offer? And what that can do is it can help give you a sense of how slippery a slope am I on? At the moment, my lawyers are telling me this is a 70% case, but how much do they have to change their view by for me to wish I'd accepted the offer? And this sort of analysis can help you look at that. It can also give you a sense for what sort of ranges you're dealing with. As you can see with this chart, on your main liability question, if you take it down to 45%, or if you take it up to 95%, you're still not really leaving the range of $26 to $38 million in terms of valuing the overall claim. So it can help you sort of create a zone. And again, you can sort of do wider testing to get a sense of which issues are really affecting the value of your case. I mentioned earlier the $100 million sort of valuation, what that outcome is worth. It is worth noting that it's different when you look at it from the other side's perspective. Broadly speaking, a claimant is thinking, I'm getting damages minus my irrecoverable costs. But a defendant will be thinking, gosh, if I lose on a particular outcome, it is, I've got to pay damages, plus I've got to pay my own costs, plus I've got to pay something towards the other side. And so what this just illustrates is actually, once you've built the model from one side's perspective, it doesn't take much amending to look at that same situation from the other side's perspective. And it's usually worse for the defendant than it is good for the claimant on any given outcome, even the defendant-friendly outcomes. And so that can be used to help find a zone of possible agreement. I could say, well, to take a much simpler example, if you've got a case where the claimant thinks they've got a 60% chance, the bar on the left, you can sort of work out, well, what is a 60% chance worth to a claimant? It's usually worth less than it is to the defendant. Similarly, if I say, well, what is the defendant's view of the case? Maybe the defendant thinks it's only a 40% case, and I can generate similar figures. And what you can do is you can identify a zone where you say, it doesn't matter whether you treat this as a 60% case or a 40% case. You can find a zone in which it's rational for both sides to settle because they can avoid paying the lawyers for the next 2 or 3 years. So I'm conscious I've sort of rattled through that, but hopefully that gives a bit of a flavor for what kind of quantitative analysis you can do to support your client in mediation when they've got a difficult decision to make, and help give them a bit more texture for the litigation risk they're facing. And again, we can happily talk about some questions again at the end, but that was what I wanted to cover in that slot. And now we'll hand over to Nadia, who's going to talk to us a little bit about cultural competence. So cultural competence obviously is increasingly a part of our legal diction. But while people use the term, we should ask ourselves, well, what does it mean? Let's make sure we know what it means. And how do we become aware of our cultural competence? And Afsana has developed real expertise in this field, and she's prepared some information to help us look at the issues, as well as some helpful tips on what to look out for during a mediation. So with that, Afsana.
Thanks, Donny. So just to give everyone a bit of context, so last week we talked about the importance of diversity in the mediation profession. Mediation is largely underrepresented by diverse mediators, whilst there's a growing number in Toronto within the diverse communities. And in fact, I think I said it was something like 51% in Toronto are visible minorities. So the need for the right kind of representation is becoming increasingly more important, and it's important that we understand, what cultural competence actually means and what our own level of cultural competency is. So a couple of definitions and distinctions that I made is about a cultural competency is that it's a person's ability to recognize, understand, and respect, and effectively interact with people from diverse cultures in accordance with their beliefs and practices. So it basically means, like, how much do I really appreciate who you are, and can I connect with you and have a conversation with you that's meaningful and that's representative of what we're trying to do here today and you yourself. Whereas equity, diversity, and inclusion is about capturing that individual's unique quality and creating an environment where those abilities are enabled for another person, something that an experienced person can give back to someone who perhaps hasn't experienced those talents, those particular views before. So equity, diversity, and inclusion is more for, say, the service provider. How are they able to provide a service that encapsulates their personality, their lived experiences, and their cultural differences? And the cultural competency piece is about understanding who they are and understanding your ability to connect with them. So we want to look at why cultural competency is essential for lawyers and mediators. And I'm not going to go through each slide. I'm very mindful of the time here as well. So I have sent these materials to you, so do have a look at your own time. But I think one of the, even though I put it at the bottom of the list, and this is by no means an exhaustive list, it's the fair representation element that's really important. Who does your client want to mediate with, and why do they want to mediate with that particular person? How will it help? You know, Gary, you talked to us about impasse. So, you know, could all these elements like unfair representation or somebody that you don't connect with mediating with you, could even that lead to a form of impasse? It's really important that we do accommodate our clients, and understanding social and emotional cues can help often break some of those uncomfortable instances where we don't really know where to go from here. Lack of cultural knowledge can often lead to misunderstandings of what the real issue with the client is. When we say, you know, is the client's day to have their say, but if we don't actually understand what the client is trying to say because of our cultural differences, then it becomes harder to settle that claim in a way that both clients will walk away, you know, a happier person, hopefully. So I'm speaking hopefully mostly to lawyers, and so we will understand that there is a duty under the rules of professional conduct to accommodate the Ontario communities, and also, you know, the Human Rights Code as well. So I won't go through that, but I want to talk about the 5 different elements that we should all be looking at in order to help our own cultural competence. And one of that is being aware of who we are and what our biases are, because at the end of the day, we are all humans. We all come with biases, because we all have an understanding of a particular issue that directly opposes what another person might say. And so that kind of psychologically helps us to build up biases, and it's only human nature. So what we want to essentially do is assess those biases. Some are extreme, more extreme than others. Some are benign, whereas others can be harmful. And so we want to assess what our own biases are, and how that looks from the outside, how that helps the others from the outside or doesn't help, and what we can do to help ourselves to identify what can be harmful and what can be helpful. Having a positive attitude toward people from different cultures and backgrounds is always a helpful way for your brain to engage in the acceptance of somebody else's beliefs that does directly oppose yours, that is very different to yours. Keeping an open mind and listening to what they're saying is incredibly important. So, you know, those are a couple of things that we need to keep in mind, you know, when we're in a room of people who are perhaps different to us. Active listening is very important. In fact, all of these are very important, but active listening, engaging in a conversation with your client or with your colleague, is incredibly important. And there's a difference between asking a question and actively listening to that answer and then engaging back into that conversation. You know, often it's kind of a passive thing. You ask somebody a question and you're not really that interested in the answer, but it's just polite to ask. And so you're doing whatever, not really, and you're not engaging in that conversation. That kind of leaves somebody feeling like they're not being heard. And in a mediation situation, if you're not being heard, well, that's really the essence of a mediation. You know, both sides need to be heard. Those feelings need to be extracted. And so engaging and asking questions in a respectful manner will only open up possibilities. Communication can be you know, it can often be uncomfortable to be asking a person who does not represent the same background as you, you know, questions like, you know, where are you from? some people might take instant offense to those types of questions. Others, like myself, I actually like being asked that question because I feel like somebody is genuinely interested in who I am, and I am proud of who I am, as I'm sure many people are proud of who they are, and they want to divulge that information, and they've been looking for the opportunity to divulge that information. But it can also go horribly wrong, because I might take the stance, well, hang on a minute. What do you mean, where am I from? I'm British, I'm from England. But what they're seeing is my color and my heritage that is not white or is not British. So they're asking from a place of curiosity where I'm from, and sometimes it can go wrong. And if you feel that that question, or somewhere around those types of questions, it has gone wrong, a quick apology literally will change everything. I've done it before in mediation, where I've come across different backgrounds and cultures that I've not been aware of, and I have very little understanding of, and I know that it's hampering my ability to communicate with that person. So how do I get around it? And there have been questions where it has gone slightly wrong, and I apologized, profusely apologized, and I said, you know, it's really hard, because, you know, I come from somewhere different as well, and it's really hard to tap into those types of questions. And instantly, by saying that you are also different to them, you know, makes that connection and brings down the barriers and opens them up to a better conversation. So, you know, communication is incredibly important, and, you know, body language is also very important. So, you know, letting people know that you are listening to them, nodding along, and really making the eye contact if you have an opportunity to do so, is also very much into how you communicate with your client or your colleague. Building a relationship is really the best way to start your journey with that client and succeed at each and every level. And it starts from the very first conversation that you have with your client. You know, are their names different? Are their accents different? What kind of accents do they have? What kind of accommodations do they need? What type, you know, who is your client? So doing a quick analysis of who your client is and what they're going to need going forward is the best way to start off your professional relationship. Sometimes one of the things that I tend to do in my terms of engagement is have a clause at the bottom. Well, it's not really a clause, more so a paragraph, just asking my clients, you know, whether they require any kind of accommodation going forward. Are there any dates that I need to avoid? Are there any times of days? Are there any dietary conditions? Those kind of things. And depending on what they write down, I can go and do a little bit of quick research to see what kind of a client I have and what kind of conversations I can have going forward. And that's like a really big relationship starter for me. So that might be something, you know, you may be wanting to consider. I'm really going to try and rattle through these ones now. So practical solutions to barriers. Implicit and unconscious biases can affect how we conduct business and represent our clients. And these are not all the problems that can come that you may come across during mediation, but they certainly are a few important ones. So looking at cultural imbalance, first of all, I know that I've been to a lot of mediation training, and I do talk to a lot of colleagues now about power imbalance and what it actually means. But in the cultural context, power imbalance is a really difficult thing to understand if you don't have that level of education behind you in terms of diverse backgrounds. So one of the things that I've always found quite fascinating is being tone policed. So there are various, there are over 200 different cultures in Canada alone. We all speak in a different way when we're speaking to our family, as opposed to when we're speaking outside into the society of, you know, the Western culture. And so our tone becomes very different. We speak more respectfully than perhaps we would in our own culture, where it's, you know, we gesticulate a lot more, and we use our voices louder or slower, you know. But there's a general way that we have to conform to the general Western society, and often that can hamper what clients want to actually say and how they actually are used to saying it, and whether, if they say it in the way their culture allows them to say it, whether you know, the mediator and the lawyers will look upon it differently. How is that going to be received? So tone policing is a way of, or not tone policing is a way of letting your clients and colleagues know that this is an open forum and we speak however we want to, so long as the real issues are coming out. Obviously, we don't want any profanities, and in that case, you should stop them. And then there's the issue of different cultures where the men don't usually allow the women to speak, or the brother or the sister, and daughter and father relationships. There are so many cultural differences between those, where the women are forbidden to speak or even raise their head or even make eye contact. Those situations can make it really difficult to understand what the client is trying to say, and what the client's instructions are. So it's a good idea to kind of go through what you can do to bring those instructions to the table to really understand your client. I've given some easy kind of things that you can do. And one of the most important things is actually recognition of the fact that there is a power imbalance. How can you bring that power back between your joint clients or between the two parties? Do you need to speak to opposing counsel and client about what you're seeing from your side, or do they need to do the same to you? You know, it has to be kind of an open forum for you to be able to attack those issues earlier on, so the balance starts to kind of level out. You know, you may even need to adjourn your mediation until those accommodations can be made. For instance, you know, some religions don't allow men and women to be even in the same room. So do you need more room? Do you need segregation between the genders? How will you receive those instructions if it isn't segregated, because perhaps a woman's voice can't be heard in that mediation? Perhaps it's not respectful. The intricacies of it can get quite complicated. And in that sense, language barriers is much the same as well. Heavy accents or language barriers can often lead to a lot of frustration and disengagement by all the parties. So it's important to know what to do, and hiring an interpreter is probably the most common thing that we as lawyers do. Or, you know, having a family member available who does speak the same common language can be helpful too. One of the things that I found with people with heavy accent is that they've actually got incredibly good language skills and good English. It's just that because I am English is my first language and I speak it fluently, I can often seem as coming off intimidating to the person who is a little bit more hampered. And so what I tend to do in those situations is actually cover my watch and just listen to them and encourage them and nod along. And if you can finish a few of their words with a smile on your face, that actually encourages them to just keep on going. And once they've got their level of confidence, you see that their level of English is coming clearer and better as you go along. The intimidation factor, whether you do it on purpose or not, can be a really a discouraging factor for people with heavy accents. So there are some religious obligations as well that we need to be aware of. For example, wearing the headdress, and there's a difference between the hijab and the niqab, where the niqab covers the face, the hijab only covers the hair. So if you've got a case in front of you where the client has covered their faces. Well, one of the biggest things that the mediation profession has been talking about since we've gone online due to COVID is that it's really hard to read people, read their emotions, read their body language. And when you've got a situation where somebody's covering their face, it's even harder. So what are the things that you can do to get around those factors and be respectful? In the R versus NS case, you know, it was a really tough decision for the Supreme Court to take in terms of how do we get around this? Do we go with fair trial or cater to the religious beliefs of this person? So also things like diet. I've been to so many mediations where, you know, people have served me ham sandwiches and I feel like, well, you know, I don't really eat pork. And so it's going to be a really long day. And, you know, those are difficult. I've never openly said to a person, you know, that you should really cater for people's dietary conditions, because I don't really eat pork, or I don't eat anything that isn't kosher, or I'm a vegetarian. You know, it's becoming more common now to ask those questions with the level of allergies that are out there. But again, it's good to be mindful of how to accommodate your client during a mediation. Prayer times and days as well, being mindful of those. And then one of the more important things is people's finances. So there are religions and cultures where it is not, you know, they're not supposed to religiously pay interest on any of their debts. So what alternatives are there? They can't build up debts full stop. What are the alternatives? Estate distribution, divorce settlements, dowries, marriage contracts, those types of issues are important for us to stay abreast and understand what the concepts behind them are. Again, you know, what can we do? How do we address religious obligations? As I said before, at the retainer stage, ask them what accommodations are needed. And I'll let you guys read on in your own time. And then the last slide is basically religious versus provincial and federal laws. As I mentioned earlier, religious clothing, there were 2 charter rights in conflict. What do you do? And then wills and inheritance, divorce proceedings, Family Law Act and the SLR don't often conform with a lot of the Sharia, Jewish or indigenous laws. What are the alternatives? Do they have, I know the indigenous have their own acts in place to deal with those things, but perhaps the Jewish and Islamic and other religious laws don't. So how do we accommodate that, as well as you know, stay within our legal limits as well, legal professionalism as well. So it's a really complicated factor in dealing with the 2 religious and federal provincial laws, and discussing it with your client and discussing it with both parties, because you may be in a situation where you've got 2 people from the same background but have 2 views on religion. So one person might be slightly more secular than the other, yet the one party doesn't want a westernized divorce, or they want an Islamic divorce, or a you know, conform with one of the other religions in terms of how they proceed with their divorce and distribution of any estate. Some of the things you can do is, you know, look at the individual circumstances and really talk to the client about their needs. And then if you don't know the answers yourself, you know, it's in our mandate under the professional rules of conduct to make ourselves competent. So speak to other lawyers who have been in that situation or have dealt with those situations. And then the test in past cases as well, and especially in R versus NS, can act as a guideline to help you disassemble some of those issues and work through them. So that's essentially it. And I tend to ask, feel free to ask any questions that you might have. It's a really big subject, and there's so many things we can do, and by no means have any of my lists been exhaustive. So if you guys ever have any ideas or want to add to what I've written, please reach out and feel free to do so.
Brilliant. Thanks so much for that, Afsana. That was really helpful and sort of rounds off quite the sort of variety of topics we've covered today. So that was super. Thank you. We've got some time now for questions. And so I don't know whether people would like to either put something into the chat or better yet, just sort of come off mute and feel free to ask.
Hi, I have a question, or I have a couple questions actually. First of all, thank you very much. It was really informative. I have a question for you, Donnie. I really liked your decision analysis. I'm an analytical person, so I really like that. I'm just wondering, so I practice mainly disability law for plaintiffs. So I'm just wondering how you could apply it more to individuals versus business, where some of the costs may be more intangible, emotional. Just wondering how I would apply that.
Sure. And I think that that's a really good sort of point to draw out, because really that analysis does the number crunching, but there are, as you rightly identify, in the kinds of cases you act in, and also in others, a whole lot of other factors. Gary mentioned earlier reputational risk that businesses might be concerned with, or management time, which people might not find it that easy to quantify. And I think it's worth saying up front, it's not that straightforward to put those sorts of points into that kind of analysis. But there's one of two ways that you can think about it. One is to say, well, if I'm litigating for each of those different possible outcomes, do I want to try and put a number value to these sorts of factors? Because ultimately, the settlement is going to, in most cases, involve a payment of money one way or the other. It doesn't have to be, but it often is. And so what you're trying to do is work out, well, what sort of number premium can I put to these factors if I litigate, and actually build them into the tree? Or even if you can't, you can say, well, at least what I've done is I've taken account of all of the financial issues. So I can say the average value if I litigate is X, the settlement is Y. If I look at the difference between X and Y, at least I've now got a quantified value for, is this the right level of discount to take off those problems that I'm concerned about? And you can, if you didn't have the valuation of the dispute, you'd be just looking at the settlement number in the abstract thinking, does this feel like the right number? At least with this, you can define the discount that you're giving to take account of those factors. Does that sort of address the question? Sorry, Gary, go ahead.
I was just going to say, I think it's a great question. I find people assess these in kind of different buckets. And what makes what Donnie's talking about so important is they need some anchoring around the financial side. And then certainly what I do is I really try and help people honor the emotional psychological side. And in the simplest terms, it says, look, here's the financial, let's just look at the numbers, and that gives me latitude. I'm not trying to shoehorn how they feel into that, but here are the numbers, and for you to make a good decision, because you need to make an informed and good decision, right? And everyone agrees with that. Then I say, but at the end of the day, if you looking at this, knowing you're going to lose money going forward, no matter how you slice it, if you still feel that's really important and that's how you wish to spend your money, God bless you, we live in a country that allows that. And by honoring it, almost everyone says, well, whoa, no, I don't want to go waste money. But the net result is it's not the mediator or their even counsel saying you're foolish to take that risk, because then they feel like my principles is how it always gets coded. My principles are just about money, and I reject that. And then they reject the entire financial analysis, which doesn't help them make a good decision. So Donnie's work there, I think, is incredibly important, and see the decision-making process as fundamentally more emotional than it is data-driven. Honor it, and then ironically, they'll take the financial analysis deeply into account.
Yeah, no, that's right. And that's part of the reason why we're really concerned not to just put forward a single number, because what we don't want is for people to think there is a single right answer here and we are telling you what to do, exactly to Gary's point.
Yeah.
It is really about saying, here are a few metrics. So, we had the average value of the different possible outcomes. We had the range of possible outcomes, look at the worst case downside, look at the upside. We had the chance of a losing outcome or the chance of doing better than the offer. And we give people sort of that set of metrics, because then people can say, well, okay, that's the financial analysis. And then if I now overlay on top of that these other concerns that I've got, I can think about whether or not this is a settlement that feels like a good response to the risk that I'm facing. Does that answer the question, Rupa?
Yeah, I think it does. Thank you so much. I also had another question for Oksana, actually, about the cultural competence. I'm just wondering what your opinion is in terms of kind of bringing up the cultural background of my client, maybe as an explanation for how it might have influenced their behavior. So basically what happens in my practice a lot is a lot of my clients might have a lot of psychological issues like depression, PTSD, those types of issues, but in their cultures, it's highly stigmatized. So they might not have mentioned it to their doctor. So there might not be as much evidence in the medical records. And this is the explanation for it, but there's no evidence at trial that I can present to show this. So I guess that's kind of the question that I come across quite a bit. And I know the law likes to treat people kind of in a vacuum and not always considering their background. But I'm just wondering what your opinion is, kind of raising that at a mediation as an explanation.
Yeah, it's a difficult one, because being lawyers, we're so used to providing evidentiary, what they call medical reports on somebody's psychological state, or their medical records showing that they have been on certain medications that help their mental state. But yeah, you're quite right. It is a difficult one, and again, it goes back to the level of education others have around the different cultures. And, it's also about social status as well, that sometimes in a case, they might not be able to talk about specific areas of their case because it damages their social status or within the community and things like that. And that's a tough thing for people who don't come from a similar background to understand. So the way I would raise it is being frank and candid, that these are real issues to my client. Unfortunately, they're not documented because their culture doesn't allow for it. And it's the same. Every culture will have these stigmas. Every culture, be it white, be it black, be it whatever it is, every culture has their own stigmas that we're not allowed to address. And so when you do address it, it's all about having the background, the understanding, and being able to present it in a way that your client will allow you to. Because don't forget that even if your client is going through those issues, they might not want you to explain it in so many words because it's embarrassing to them. If their brother or sister, mother or father is sat in the room or in the courtroom, it's embarrassing for that client to have their reasoning behind why they can't release certain information to the courtroom or the mediation in this case. So again, talking about your client, sitting down with them and explaining what is reasonable for you to talk about and what is it reasonable for you to present. One of the things that I advocate the most, and one of the things that people say comment on my presentations the most is the candidness of a person and how you sound and how you come across. It has to come from a place of genuine. You know, you have to remain genuine and you have to remain understanding and respectful. And so long as that gets put across to who you want to present that information to, I think you'll do just fine. Does that answer your question?
It does. Yeah, thanks. It is a challenge. And I think the problem with the law is they treat the reasonable person as, you know, usually a white male. So,
Exactly.
you know, kind of trying to explain that sometimes can be a challenge, especially, you know, when opposing counsel and the mediator are not culturally competent either. So thank you.
No, you're welcome. Does anybody else have any questions? So, Gary, I've got a question for you, and it's more kind of talking about people's personalities in a mediation. And, you know, I know that I talked about cultural competence, and that can often lead to impasse as well. But in more general terms, I've been in mediations where it's been really hard to balance people's different personalities that make you think that, okay, well, this person is not going to open up, so there's nowhere else I can go. I can't force them to. What would you do in that position?
You know, I very strongly honor people's decision making and presence and choices that they make. And so, similar to what you said, Afsana, I tend to be very frank with people and very direct in a respectful way. And so if someone doesn't want to open up, and what you said culturally is absolutely true. And I think individually too, there are some people who just don't want to come out and say that I was, you know, I've been permanently, my mental state is permanently damaged in this life, right? They don't want to talk about it. They don't want to go there. And so I would be very frank with them around to say, look, you have a choice. The way our system works, and I'm not apologizing for our system, I think there's real drawbacks to it. But the reality is, if you choose not to talk about this, you will end up with less compensation. That is just going to be the reality, whether it's today or whether you go to court. And if you choose that, and let's talk about it, and I respect it completely, whichever way you choose to go. So please tell me what is going to be most important to you, because I want to meet and help you achieve the best outcome that is most important to you. And then people tend to, like you said, they tend to open up, at least on the level of process, to say, I understand that I'm going to probably get less money, and I don't care. This is too important to me. And sometimes I have counsel take me in the hall and say, that's not a good answer. And I say, well, you know, at the end of the day, this person has to live with the decision, don't they? Like if you get them another $50,000 and they hate themselves, how is that a good outcome? And just engaging carefully and respectfully and deeply. Similarly, I've said to people who have big personalities who like to shoot from the hip with, you know, and they make kind of comments, I say, look, you are free to do that. Have you seen the response on the other from the other party? Like, and if that means you're going to do less well here, what do you think it's going to mean in court if you go down that route? If a judge or jury decides they really don't like that approach, and I look at them and say, and your approach is your approach, I accept it. If it means X, Y, Z, what would you like me to do about that? And again, then you'll watch some people change. They go, you're right, I'm being a jerk. Okay, I get it. And not because I've said you're being a jerk, because that's judgmental. People never change from judgment. It's because I've given them a choice and I've helped them see the choice, the consequences of those choices. And I follow it. And if I'm, you know, working with one person, the most challenging is when you have a lawyer of one particular personality and their client is a very, like, one's really quiet and one's really extroverted, you know. And then I tend to play to both. And every once in a while, I'll turn to counsel if they're the extrovert, and I'll say, give me a second, if you don't mind, let me just have a 2-minute conversation with your client. Please stay here. don't go anywhere. But just let me have a chat directly with them. And they're great. They go, sure, no problem. And then I get a chance to draw, the quieter person out. But I ask permission for all kinds of things. And people, if you ask permission to do things, people get almost always granted. But if I just plow ahead, then they jump in and go, hey, what are you doing there? So it's really engaging with people where they are and not being shy about the consequences we're all trying to parse, because the bottom line is, I want you to make a good decision for you today. Are you okay with that? And people go, yes, I am. Great. And that gives me latitude to help them do it.
And I imagine those issues must come up a lot, particularly in the employment context. And I was wondering, Nadia, whether you see some of those play out, and in particular, if you've got employees who, for various reasons, need to resolve the dispute quickly so that they can get on with their lives, whether you see employers trying to take advantage of the employee's urgency and what can be done about it.
Yeah, I think that's a great question. And I do see it certainly in the employment context. There are many situations where, let's say, the employee, for either personal or financial reasons, really wants to or needs to settle the file quickly. And if employer counsel obviously, knows about that, then they might try to take advantage of it by putting forth a lowball offer, by thinking that the employee is going to take it anyways. And we actually represent employers as well, so we see it from both sides. And frankly, a lot of the times in the employment law context, emotions are running high, especially in situations where allegations have been raised, between both parties, and they're really upset about how they have been treated. And sometimes employers can also feel really bad about how the employee has treated them. So I think that can certainly impact the negotiation process.
Great, thanks, Nadia. Thank you, Gary. I want to thank both of you, Gary and Nadia, for joining us today. It has been an absolute honor listening to you both and working with you both. I also want to thank Saba for allowing us to put this presentation up, and it's been great putting this together and speaking to so many of you guys. Please don't forget that the program may be eligible for 1 hour of substantive CPD hours. Lastly, my gratitude to Donnie. Thank you so much for asking me to chair this with you. It's been an absolute honor, and I've really enjoyed it. If any of you attendees have any questions, Donnie and I have sent you some materials, which also include our contact details. So please do get in contact. I know all of the issues that we've talked about are very large issues, so I'm sure we'll all be ready at hand to help you. So thank you again.
And thanks from me, Afsana, so much for all of your help and for sort of putting up with me as we've done this. And to Gary and Nadia, it's been great. Thanks a lot.
Thank you so much,
everyone. Take care.
Cheers. Bye all.